Companies Act, Section 288 Submission of periodical reports to the Tribunal. Section 288 of the Companies Act, 2013 pertains to the obligations of the company liquidator to provide periodical updates to the Tribunal during the process of winding up a company. This section is designed to ensure transparency, oversight, and proper judicial supervision over the progress of the liquidation proceedings. It also empowers the Tribunal to review and modify its own orders under certain circumstances upon the application of the company liquidator. Below is a comprehensive elaboration of each subsection under Section 288. Subsection 1. Obligation to submit periodical reports to the Tribunal. Under Subsection 1 of Section 288, the company liquidator appointed to carry out the winding up process of a company is legally required to submit periodical reports to the National Company Law Tribunal, NCLT, which oversees the winding up. This obligation exists to ensure that the tribunal remains regularly informed about the ongoing progress of the liquidation. Specifically, the provision mandates that the company liquidator must submit a report at the end of every quarter. This quarterly report should comprehensively detail the progress made in the winding up of the company during the preceding 3-month period. The format and manner in which these reports must be submitted are to be prescribed by rules or regulations, likely framed under the Companies Act or by the Tribunal itself. These rules may include guidance on the structure of the report, the nature of the details to be disclosed, example, asset realization, settlement of liabilities, distribution to stakeholders, and the timelines for submission. In addition to the mandatory quarterly report, the company liquidator is also expected to furnish other periodical reports as may be required to provide continuous updates to the tribunal, particularly when significant developments occur or as directed by the tribunal. Subsection 2. Tribunal's power to review and modify its orders. Subsection 2 empowers the tribunal with the authority to review and modify its previous orders passed in connection with the winding up proceedings. However, this power of review is not automatic. It must be exercised upon an application made by the company liquidator. This provision recognizes that, in the course of liquidation, circumstances may evolve or new information may come to light which could render earlier orders of the tribunal either impractical or in need of refinement. In such cases, the company liquidator can approach the tribunal with an application explaining the need for a review or modification of a specific order. Upon receiving such an application, the tribunal may consider the reasons and, if it deems appropriate, review its earlier orders and make modifications as it thinks fit. This discretionary power allows the tribunal to ensure that the winding up process is carried out effectively, efficiently, and in accordance with the changing circumstances or legal requirements. Purpose and importance. The combined effect of these two subsections is to establish a mechanism for ongoing judicial oversight of the liquidation process and to ensure accountability on the part of the company liquidator. The requirement of submitting periodical reports creates a continuous channel of communication between the liquidator and the tribunal, which facilitates early detection of any issues or delays. Moreover, the ability of the tribunal to review its orders on the liquidator's application ensures procedural flexibility and allows the tribunal to respond dynamically to the realities of a complex liquidation. This supports the overarching goal of the Companies Act, which is to promote an orderly, fair, and legally compliant winding up process. For more details, contact us.